Hi everyone, my name is Divya Ganesan with metric number 278157. I'm going to describe about the issue of this case study. Sia Teng Lo and son Sundrian Berhad is the focus of this case, to put it bluntly. Sometimes in September 1985 failed to return the debt in full. Additionally, Interfinance Berhad acquired a sale of the disputed property and respondent property was sold at public auction. On the basis of guarantee, the respondent sued the applicant in 1994. Since there was no disputable matter and a preliminary judgment had been rendered, the appellants appealed to the Court of Appeal. The labels that the parties decided to apply to a significant document are not legally binding on the court when constructing contracts. As properly interpreted, the agreement that the applicants signed in the current instance purports to fit the criteria in Section 77 of the Contract Act 1950. Let me describe about the type of security the third party Chairgo obtained from the STLS and SB company directors. Essentially, the form of security that the third party cargoes acquired from the directors of STLS and SB company in exchange for their property that was assessed to Interfinance is charged. A typical type of security known as a charge is one of the established in the financial institutions benefit in return for the provision of a loan facility to the buyer in order finance the acquisition of property investment. As it well known, the torrent system is used to clarify the charges in this case. Thank you.
Hi everyone, my name is Erma Natasha binti Janalu and my metric number is 2782C1. In this part, I would like to talk about question 2, which is the loan defaulted was defaulted in September 1985 and STLS and SB made some payments in May 1992. Explain why the land was still auctioned by the chargee. Explain if it's legally right for Interfinance BHD to sue the charger for the balance of the outstanding loan. Helen obtained a loan from the previous owner respondent. The loan is pledged to a lease on the appellant's land. Last payment made by appellants against the loan was in May 1992. Appellant disregarded the notice and its consequence the respondent filed the originating suit for land sale order. Appellant argued that the proceeding of the redemption had been prevented by the due time limit inactive loans for a period exceeding 6 years and the respondent did not initiate any proceeding to sue that party. The High Court made the order prejudicial to the appellant and the appellant appealed to the Court of Appeal. The court may decide to dismiss the appeal. The respondent's application is to sell the land through a public auction rather than an act of earning return the loan owed. Section 21(1) and 2 of the Act the 1953 time limit does not apply to the facts of the case here. In the current case, the cause of action of the respondent, the right to enforce the statutory remedy of the sale order, arose until after the appellants failed to cure the breach state in the notice. A suit can be filed. According to the Abdul Aziz Muhammad case, the appellant received an 300,000 ringgit loan from the forerunner of the respondent bank in 1984. The loan was secured by a chargee against the appellant's land. After the final repayment on 28 January 1986, the appellant fell behind on payments. The respondent submitted a request on 6 April 2001 for a National Land Code Section 256 order authorizing the sale of the property. On 10 May 1992, the High Court approved the selling order. This was an appeal regarding that decision. The limitation issue was the only one that was brought out in front of us. Because the respondent action was time-barred by limitation, the appellant's counsel claimed that there was a cause to the contrary in the sense of Section 2563 against the making of the order for sale. He said that limitation action of 1958 Section 21.1, he argued that respondents' conduct was an effort to recoup the principal among the money that the chargee had secured. No action may be instituted to recover any principal sum of money secured by a chargee on land after the lapse of 12 years from the date the right to receive the money accrued according to Section 21.1 of the Civil Practice Act. According to clause, theft of the chargee ensures the respondent chargee had a right of action if the next installment was not made by 28 February 1986, as was claimed by the attorney. Counsel contend that because the right to bring the action arose in February 1986 rather than on 6 April 2001, the action should have been filed by February 1998 in order to circumvent the prohibition of Section 21.1. Without speaking with the respondent counsel, that dismissed the appeal. So that's all from me. Thank you.
A very good day. My name is Vilasha Shankar and my metric number is 281069. I would going to present about question 3. What does question 3 about? Based on the guarantee document, the respondents sue the appellant. But the appellants alleged that the claim was filed out of time. Explain what it means by out of time in the statement. At the hearing of the application for summary judgment, why the filing was not out of time according to the Judicial Commissioner. So, from the question, we need to know that what does out of time means and why filing is not out of time. Let's go to the next slide. Here is the answer for question 3. Based on the case study, one has mentioned about out of time. Out of time means there is a high possibility that the claim will be dismissed if it was filed after the limitation period had expired. For instance, most of the standard construction contracts have a time limit. According to Section 6(1)(a) of the Limitation Act 1953 says that he or she has 6 years from the date the contract was broken to sue someone who broke a contract with him or her. From the statement given by appellant that the claim was filed out of time without any proof. However, the last payment made by the appellant in the year 1992 proved to exceed more than 6 years from the breach of contract. But in this case, the discussion is about land disputes. According to Section 9(1), the Limitation Act 1953, the time restriction for land recovery action is a little longer, around 12 years. Besides that, the respondent claims that the file was not out of time since the agreement was made for 12 years. Therefore, the appellant was given the wrong statement on the time period of the contract made. The respondent can sue the appellant until the time period of the contract ends. Since the appellant cannot make the payment due to bankruptcy in time, the land will be auctioned to the public starting in the year 1994. According to the section, once the contract is signed, the party should take responsibility for paying the amount until the time period ends. Consequently, if the agreement exceeds the time period, there is no point to sue the person. As a result, suing someone whose agreement has run out of time is a waste of effort. That's all from my part. Thank you.
Next is question number 4. At the Court of Appeal, the main issue is the respondent's action is out of the time limit. How does the court differentiate the time limitation for filing for a guarantee and indemnity? If the paper contained a guarantee, the deadline for initiating a claim is over 6 years would have started ticking away on September 1, 1985, the date the contract was broken. The Seah Tiong Loh and Sons Sdn Bhd illegally missed a loan payment in September 1985, according to the Interfinance Berhad. As a result, the court began accepting guarantee in September 1995. A contract of guarantee, however, differs from an indemnification contract. The deadline is over at the set time of the submitting an indemnification claim starts to run only as of the day the loss was occurred. Interfinance Sdn Bhd had demanded RM616,754.57 from the Sia Tiong Loh and Sons Sdn Bhd. However, the appellants were unable to settle the amount, hence the company entered bankruptcy on that day. Additionally, on 9 August 1993, the Interfinance Berhad began selling the land at public auction based on indemnification. Thank you.
Assalamualaikum Doctor. My name is Nashida binti Ayub and my metric number is 27811C. So I will present question 5. According to section 77, an indemnity contract is a contract by which one party promise to protect the other from loss caused to him by the promises on conduct or by the action of any other person. A contract of guarantee, on the other hand, is an agreement to keep the promise or to free a third party from obligation in the case of violation. The person who offers the guarantee is known as the surety. The person whose default the guarantee is made for is known as the significant debtor, and the person to whom the guarantee is issued is known as the creditor. One can orally or in writing make a pledge. When a payment is missed by the principal borrower or debtor, the obligation under a guarantee becomes payable. When there is an obligation but there is no failure or breach by the major debtor, the agreement is not a guarantee. On the other hand, a promise to take on responsibility for a debt whenever the party to whom the promise is made should take on responsibility is a different issue that needs to be evaluated separately. Although the phrase guarantee and indemnity are commonly used interchangeably as if they mean the same thing, a guarantee is a commitment to assume responsibility for another party's obligation or debt in the case of that party's default. However, the indemnity will take precedence if a third party is committed to hold a person accountable for the dealer's loss. In that case, a person will be held accountable. As a result, a guarantee requires a third party to violate the terms of the agreement, whereas an indemnity arises from the occurrence of an incident. The indemnifier is told to have the main responsibility. Two parties are involved, the bank or lender receiving indemnification and the party providing the indemnification, the person giving the indemnity. The party providing the indemnity is primarily liable. This means that even if the debt cannot be collected from the original debtor, the indemnifier is still liable to the indemnity recipient. Indemnities are now a common addition to guarantees as an additional layer of security. This is regardless of the lawfulness, nature or character of any underlying obligation and independent of any default by any other party. The indemnifier's liability is distinct from and unconnected to anyone else. The beneficiary of a guarantee should aim to include a conversion to indemnity in its guarantees, since the indemnifiers are treated less favorably and because of what an indemnity is. In proportion to changes in the liability of the principal obligor, the guarantor's obligation is reduced or removed. Indemnification provisions in contract have traditionally been seen as being upholdable in a court of law. However, some courts have restricted the enforceability in circumstances where the harm or loss that occurred was thought to be unreasonably harsh or logically unexpected by the party that would be required to pay for the damage.